Okay, good evening, everybody. Thank you very much for coming on this, those in person, on this extremely cold, wintry night. And welcome to those people who are attending online. This is the third in our series on the Illegal Migration Act 2023. This session is entitled and was designed around Rwanda third country removals and interim measures. And of course, we've had a significant change in the legal landscape since we conceived this seminar. But we do think that it's important that we look at the judgment, look at the implications of the judgment, and to look at what might happen next in order that we're prepared for whatever the government has to throw at us as claimant lawyers. I'm going to introduce the panel in due course. One of my colleagues who have all been involved in the Rwanda case from beginning to end, and also to welcome Alex Grigg, who's online, one of our colleagues. So we're looking at the proposed third country processing schemes and their lawfulness in light of the Rwanda ruling from the Supreme Court, Rule 39 interim measures from the Strasbourg Court, and how they will be affected by the Illegal Migration Act, parts to be commenced, parts which have been commenced. So I just want to tell, obviously, the people in the room and the people online about the judgment. I won't spend too much time on the Supreme Court judgment because most people are very familiar with it, I think. But just to remember that it was the government's appeal against the majority decision of the Court of Appeal that it was unlawful to send people to Rwanda for the purpose of their asylum claims being processed there. And the conclusion of the Court of Appeal majority and the Supreme Court substantial grounds for believing that there was a real risk that asylum claims wouldn't be determined properly in Rwanda, and that asylum seekers would in consequence be at risk of being returned directly or indirectly to their country of origin, i.e. would be liable to refoulement. And in the event that those genuine asylum seekers, refugees or asylum seekers would face a risk of ill treatment, they shouldn't be returned there. Importantly, the evidence of the UNHCR, who had appeared at all stages in the proceedings, was regarded as critical to that evaluative question, in particular because of their own unique expertise and the expertise they had of the Rwandan asylum system and then their institutional competence. And so those are that's the broad and main issues that the Supreme Court had to decide. Importantly, they looked at the question of what test had been applied by the Divisional Court, and they concluded that it should have been looking at the Thirring test, i.e. whether there was removal would expose people to a real risk of ill treatment as a consequence of refoulement in another country. And the Supreme Court was concerned, as the Court of Appeal had been concerned, that the Divisional Court had suggested that its function was reviewing the Secretary of State's assessment and deciding whether it had a tenable view, rather than making its own assessment. And although there were places where the court had recognised that they had to carry out the assessment for itself, the Supreme Court concluded it wasn't easy to determine what test had been applied, and in any event found that whatever test had been applied, the Court of Appeal had been entitled to interfere with its conclusions, because they themselves then examined the evidence for themselves and reached the conclusion that Rwanda was not safe. But importantly, when the Supreme Court was looking at the case and the Court of Appeal's approach, they accepted that the Divisional Court had erred in its treatment of the evidence, particularly in relation to risk of refoulement, particularly in relation to their question engagement with the UNHCR evidence about the processing of asylum claims in Rwanda, and that their approach that the executive's expertise in evaluating the worth of promises made by a friendly foreign state had been in error. And so the court had to go on to make its own assessment of whether there were substantial grounds for believing that there was a real risk of refoulement. And it wasn't required to accept the government's assessment or evaluation of the assurances unless there was compelling evidence to the contrary. So that was the government's case. And so just applying the straightforward, in some ways, or the long established, might I say, principles in Othman and Zamalopni, the court was able to reject the Secretary of State's suggestion that the value of assurances given by another state was analogous to, for example, whether the actions were in the interest of national security. And that is a very important maintenance of the role of the court in these in the Human Rights Act case. And the Court of Appeal and the Supreme Court found that the Divisional Court dismissal of the UNHCR evidence regarding Rwanda's failure to abide by assurances under the Israel Agreement, which was the previous agreement that Israel had entered into with Rwanda between 2013 and 2018, identified defects in the asylum system, that there had been inadequate treatment of that evidence, and that they should have attached much a greater importance to that UNHCR evidence, given, as I said at the outset, its status, role, and expertise and experience. The risk of refoulement was a concern with the general human rights situation in Rwanda in terms of the processing of asylum claims, and their question about their compliance with international obligations, the adequacy of the asylum process, the non-compliance with assurances given under the Israel Agreement, and all those, that's taken all together and established that there were substantial reasons for believing that there was a real risk that asylum claims wouldn't properly be determined, and that asylum seekers would in consequence be at risk of direct or indirect refoulement. So that's much we know. The Court of Appeal, the Supreme Court chose in those circumstances not to determine the cross appeal. There were two grounds of cross appeal. One in relation to conditions in Rwanda, which was in addition to the risk of alleged refoulement or refoulement found out. And the second was specifically, which wasn't discreetly and specifically determined, the cross appeal ground in relation to the Ilias duty, or the question of whether the Secretary of State had failed to discharge her procedural obligations under Article 3 to examine thoroughly the question of whether there was or was not a real risk of an asylum seeker being denied access in the receiving third country to an adequate asylum procedure, such that they were not protected against refoulement. So those matters potentially could come back if we were ever to enter a new or next stage assessment of Rwanda, or any other third country for that matter. So that's what we know, and I'm sure I don't want to labour that too much, because I want to then go on to introduce my colleague Isaac Ricca-Richardson to talk about what to do now with notices of intent and inadmissibility, because that's obviously what we need to think about. Well, there was 20,000, I think, NOIs being issued, and they were certainly being issued up until the judgment, and certainly after the hearing in the Supreme Court. So Isaac is one of my colleagues who was working on the Rwanda case with me in my team, and a barrister at Garden Court in immigration and public law. His detailed biography was on the pack. Thanks, Isaac.
Hello, everybody. As Sonali says, my name's Isaac. I'm a barrister at Garden Court. I'm going to talk to you today, hopefully quite briefly, about the practicalities of getting asylum claims admitted to the substantive procedure in light of the Supreme Court's decision. So the first thing that I'm going to talk about is the situation if your client has an inadmissibility decision already, and what you can do in those circumstances. The second thing is if your client has a notice of intent in respect of removal to Rwanda, but up until now, the Secretary of State has refused to make a decision on whether the claim is inadmissible. And then the third thing is kind of some practical tips on how to frame representations on both of those things. So I presume that everybody here will know this, but just in case anybody doesn't, what I mean by an inadmissibility decision is a decision that the Secretary of State will not actually determine the asylum claim and will instead send the individual to some third country, in practice Rwanda, for it to be determined. So the first thing to say about people with outstanding inadmissibility decisions is that I think, from as far as I can gather, that this cohort of people is relatively small. So it's mainly people who received inadmissibility decisions before the first flight was due to take off. That is just going to go on and off. So I'm actually going to have to say something rather than just rely on what's on the screen. I hope that's all right with you all. But basically, there may be also a small number of people after that first flight who received them, but my understanding is that after that, the Secretary of State basically stopped issuing decisions. But anyway, for those people that do have them, the Secretary of State's position seems to be that she was basically waiting until after the conclusion of this litigation to decide what to do with them. Obviously, it might be thought that it's as simple as we won, get over it, both decisions. It probably should be, but it might not be. And so it's worth bearing in mind kind of the things you might need to address in order to get the Secretary of State to accept that. So as you can see on the screen, in my opinion, the key provision here is Rule 345D. That applies both to the claims before and after the 28th of June 2022, because that rule still exists post-NABA. Basically, that says that the Secretary of State will admit a claim if he believes, that removal to a safe third country will not take place within a reasonable period of time or is unlikely to take place. So in a sense, that is a mandatory provision because it says will admit the claim, but it's still the Secretary of State's opinion that is crucial, right? So it's whether the Secretary of State believes that it will take place in a reasonable time. That means it's him that you've got to persuade that it won't, and obviously his opinion that you have to challenge by JR if that's necessary, if they don't accept the representations. And in addition to Rule 345D, you'll also want to rely on the guidance, which I'll come on to in more detail in a minute. And you'll also want to rely on any kind of compelling specific circumstances relevant to your client. So there are two senses in which I think those personal circumstances are likely to be relevant. The first is that you can use them to argue that the delay in your client's case will have a greater effect on them. Obviously, reasonable period of time is not a fixed period. And so, like with any claim, against delay in making an asylum claim and so on, what is reasonable is likely to depend on personal circumstances. So anything that you can do to show that the effect is greater on your client should get them to the front of the queue to be removed, as it were. The other sense in which personal factors are relevant is that there is a second question, completely different to whether removal will take place in a reasonable time, which is whether third country removal is unsuitable. That's pre-28th of June 2022 or post-28th of June 2022 is whether there are exceptional circumstances. So that test is obviously a little bit higher now for more recent claims. In both cases, you're trying to say basically, regardless of how long it will take, even if you could do it tomorrow, it wouldn't be appropriate for my client. And I'll come on to some of the things you might want to rely on in a little bit. So the second cohort of people is people with notice of intent but with no decision. This cohort is far bigger than those with decisions. The Guardian in March this year said that there had been 24,000 recipients of notice of intent. So that's 24,000 people in this queue, potentially. That is almost certainly not going to have got smaller in the time since, because as far as I'm aware, in almost every case, the Secretary of State's just been saying that we'll wait until after the Rwanda judgment before making a decision. It's likely to have grown since then, because there are obviously more people coming all the time. And if Section 2 is brought into force, which Eva will address you on shortly, then it will get almost exponentially bigger, because the Secretary of State will then be under a duty to attempt to remove every single person who arrives unlawfully. Right? 24,000 March 2023, getting bigger all the time. And that's relevant not just because it means there's a number of people who this applies to, but also, as I'll come on to, because obviously it goes to the extent, the likelihood that someone's going to be removed in a reasonable time if there's this many people that are going to be removed. So, again, here, Rule 345D does not apply, because the way the rules are structured, that only comes into place when a decision has been made. That's actually a bit of a gap in the law, because the rules suggest that they should be applied as soon as the circumstances giving rise to an inadmissibility action present themselves. So it makes it look like the Secretary of State sees a claim, goes, this is inadmissible, does something straight away. Obviously, in reality, what the Secretary of State has been doing is just been putting people in limbo, so they can't access Rule 345D to get back into the process. Nothing happens at all, right? That's problematic, but it's not the end of the matter, because there is at least guidance, and that's the inadmissibility guidance, which is referred to there on screen. So that's what you're going to make your representations against if you've got a notice. It's necessary here to separate out the two different time periods. So if a claim was made before the 28th of June 2022, then it's version 6 of the guidance you have to rely on. That's archived, but it's still available online. There are some excerpts of that on screen, not on screen at the moment, but when you get the slides, you'll see them. But basically, the thrust of that guidance is the inadmissibility action must, and again it's mandatory, must be discontinued where it will not be possible both to make an inadmissibility decision and to effect removal on the basis of that decision within a reasonable time. So the whole process has to be done in a reasonable time. That obviously begs the question of what a reasonable period actually is. Unfortunately, the guidance says that there is no strict time limit to that, so we can't just go, it's been 6 months, it's game over. But version 7 of the guidance quite helpfully says that for claims before 28th of June 2022, it may not be appropriate to take an admissibility action where more than 6 months have passed since the claim has been made. So that's not binding, obviously, but it's quite a good starting point to latch on to say, in most cases, it shouldn't be longer than that. And lastly, and quite unsurprisingly, the guidance again states that the quote particular circumstances of the applicant will be relevant. So that's again the point that I've already made. Claims made after 28th of June 2022, you're looking at version 7 of the guidance. It's basically the same as version 6. There's very little different. But it additionally says in terms that the admissibility process must not create a lengthy limbo position. And what it goes on to say is that that's where the claim is not decided at all, either here or in a third country. That's quite a helpful sort of statement of principle as to what the Secretary of State's policy is at least supposed to be, because clearly that's not what's happening, and you can argue that it's being not properly applied. So that's kind of the whistle-stop tour of the relevant rules and the guidance. To summarise, I think the 3 key points are that first, the question is whether the Secretary of State can make a decision and remove in a reasonable time. Second, there is no strict time limit for that, but if a client has already been in limbo, if we can call it that, for over 6 months, or if they're likely to be in limbo for almost 6 months, there's probably a pretty good case to at least make representations. And the third thing is that personal circumstances are always key to everything. The rules, the guidance, are all about that. So bearing those points in mind, there are 4 things that I think should be covered in any representations. So the first is obviously to set out any helpful bit of the rules or the policy that you rely on, and hopefully the slides have kind of just set that out for you. You'll be able to take them from there. The second point is that when you've done that, you want to show both the period your client has already been in limbo and the period that they are likely to be in limbo in addition to that. I think before the Supreme Court judgment, so I actually applied for legal aid in a case like this, and the legal aid agency said, we'll just wait for the judgment, Might have been a while, but it might be sorted soon. And we just decided to wait until afterwards. So then I guess the Secretary of State could have an argument that even if it's been a while, it might not be very much longer. My view, and I'm thinking any reasonable view, is that they can't now say that the removal will be taking place in a reasonable time. And for that, you can rely obviously on the Supreme Court's decision. You can rely on the lack of evidence that those issues are going to be fixed anytime soon. There's obviously statements from ministers to the press and so on about how they're going to fix it. That's not evidence. It doesn't prove anything. And the third thing you can rely on, and I think this is almost just as important really, is evidence that even if the scheme becomes operational, there will be still significant delay for the vast majority of people who have notices of intent. Right? So that's obvious. It's obvious from the size of the cohort that I've already described. And it's also obvious because it's been repeatedly stated by all parties to this agreement that the numbers are going to be low. So it's not going to be everyone sent there. Everybody knows that. And there are some sources in the PowerPoint presentation, so they're linked. There's one from the BBC, one from a parliamentary question, and one from the Times. That's ministers from the British government and individuals from the government of Rwanda all saying that it's going to be in the matter of hundreds each year. And there's also wide reports, and this is the BBC article. There's wide reports that when the government of Rwanda agreed to it, they said realistically it's going to be about 1,000 people in the first year. So obviously it's not really core evidence, but it all paints a picture that there's far fewer places than there are numbers of people who have notices of intent. It's probably also worth, I would say, referring to that kind of background. And then the third thing you want to refer to is any reasons why delay is particularly harmful to your client. So I've already referred to that. The most obvious example, of course, is any kind of mental health issues or medical issues that are exacerbated by delay. And one thing that might be worth thinking about if you have time, or maybe after reps, but in advance of any potential JR, is getting psychiatric evidence. If there are mental health problems, psychiatric evidence that directly talks about the effect of delay will be really helpful in that regard. And then the fourth and final thing, as I flagged, is any reasons why, even if there was no delay, the circumstances of your client are such that it would never be appropriate to remove them to a third country for their asylum claim to be processed. Again, this could include mental health, but anything like trafficking or torture indicators might also be relevant. And in the case of our client for the Supreme Court, one of the things that we relied on, which obviously didn't work at first, but might work a bit better now, was that he's got Article 8 rights in the UK, so he's got family members here. And that's not obviously something that the Secretary of State has to take into account, but that word unsuitable is fairly elastic, and it seems to be the only point in any of the structure of the rules that really fits general kind of compassionate or human rights factors. So really, I'd say anything that you can think of that sets out this case as one that is not suitable or where there are exceptional circumstances is worth putting in representations. Obviously, if your representations are rejected, you'll be in the realm of judicial review. We don't need to get into that now because hopefully the Secretary of State will be reasonable as ever and say yes to everything. So I hope that's helpful. And if you have any questions, I will answer them at the end. Thank you.
Thanks so much. I think it's worth pointing out that the individual human rights decisions were quashed in all of the individual claims that were before the Supreme Court. So it was the broad question of safety that was still at large, but as Isaac said, you need to merge those two issues. So thank you. I'm now delighted to introduce Eva Doerr. She's going to from Garden Court, again, public law and immigration barrister, and as you can see from her biography in the papers. So she's going to just talk about the Section 2 duty to remove under the IMA.
Thank you, Sonali. I do apologise for my voice. I hope you can hear me all okay. As Sonali says, I'm going to be talking to you about Section 2 of the Illegal Migration Act, which contains the duty to remove. Now, in terms of the contents that I'd like to cover is first I'm going to make some introductory remarks about the Section 2 duty. Then I'll talk to you when the duty will apply, any exceptions to the duty, and then what that means for any future challenges to attempted removal of asylum seekers to safe third countries where that removal duty actually applies. I should also say that my slides also cover suspensive claims, but our colleague Alex is going to talk about it, so it's just there for reference rather than for me to actually go through them. Now, by way of introduction, really what Section 2 of the IMA is the latest incarnation, or perhaps a symptom, of the UK government's commitment to stop asylum seekers making, not only asylum seekers, but migrants crossing the English Channel by boat or by lorry. And the provisions are not yet enforced. That's my second point. The provisions are not yet enforced. You'll be glad to hear, and there are actually serious doubts as to whether the provisions will ever come into force. Now, to give a bit of context to that, the Illegal Migration Bill was first published in March 2023, and that was really in the wake of the Divisional Court judgment in the Rwanda litigation that Sonali has already spoken about. So really, the government perhaps felt quite emboldened and confident that they're going to be able to remove people more on a mass scale to Rwanda, and that therefore a duty to remove vast amounts of people might actually work in practice. Since then, however, and as you have heard earlier, the Court of Appeal and the Supreme Court both found that the Divisional Court was wrong, that in case, or that in fact, Rwanda is not a safe third country to which asylum seekers can be removed to lawfully. And the real problem about this duty to remove is that unless the government can actually come up with willing safe third countries that have sufficient capacity to take lots and lots of people, then it's really an illusion to think that this could ever work in practice. And that is why there are serious doubts over whether this duty will ever actually come into force. I've set out on the slides as well at the bottom references to the documents that were published by the UNHCR following the publication of the bill, and then also following the bill becoming an act. Really, the UNHCR has made very clear that in its view, the core provisions of this, which Section 2 is one of this act, are inconsistent with the UK's obligation under international law, so under the Refugee Convention. And in fact, what the UNHCR said is that, and I'll come on to that a little bit later on, that really what the act does is that it extinguishes the right of asylum seekers to claim and be afforded refugee status in the United Kingdom. And it also creates a real risk of referral. Now, when does the duty to remove actually apply? There are 4 conditions, and that is what is set out in Section 2. There are 4 conditions that must be met in order for the duty to remove to apply. The first condition is illegal entry. So a person must have entered in breach of immigration provisions. The second condition is that the person must have entered on or before the 20th of July 2023. Now, helpfully, Section 3 provides that this date is actually subject to change, and that's helpful for advisors because I think it's highly likely that if Section 2 ever came into force, that date would change to the coming into force of Section 2, rather than it applying retrospectively. Regardless of that, it's quite a difficult position currently, I think, for advisors to advise asylum seekers who could potentially be caught by the duty, because you might want to tell them about it, or have a legal obligation or a professional obligation to tell them about it. But at the same time, I think it's fair to say and fair to advise that the likelihood of this ever actually applying to the person is probably low. The third condition for the duty to remove to apply is the condition that a person must have come directly. Now, the person must have therefore travelled, or I think I've just said this incorrectly, so sorry. The condition is that a person cannot have come directly from a country where they're persecuted. But in turn, what that means is once a person has travelled through a safe third country, they will meet condition 3 of the duty to remove. And this is interesting because coming directly is a concept that we know already, because Article 31.1 of the Refugee Convention already talks about the concept of coming directly and what that means. And in international laws and refugee law, it's taken also to include persons who, for example, briefly transited through other countries. The IMA, however, expands the definition of what coming directly actually means, and it actually includes people who've simply passed through or stopped in other countries along the way. Yeah, so really I expect that if the duty ever comes into force, this will definitely be subject to future litigation, and the UNHCR has also expressed their grave concerns about this provision. And really, when you think about it, and when you think about perhaps your clients who have notices of intent to go to Rwanda or perhaps inadmissibility decisions, it's very, very, very difficult within your client group perhaps to find people to whom this condition would not apply because of the way in which it's cast and how broad it actually is. And then the fourth condition when the duty applies is that the person requires leave to enter or remain and does not have it. So really what this shows is that the duty to remove is, as I just said, going to apply to the vast, vast majority of asylum seekers that you'd be dealing with. Then moving on to the exceptions to the duty to remove. So there are currently 3 exceptions to the duty, but the Act provides that the Secretary of State may include additional exceptions later on, but we don't know yet what that might look like. Now, exceptions are either temporary or permanent, and I'll come on to that. But the first two are temporary exceptions or temporary suspensions of the duty to remove. And that is for unaccompanied minors. Yeah, that's the first exception. But this is suspended only until the person turns 18. So really, it doesn't mean that the duty to remove doesn't apply. It just means it only applies when the person turns 18. Additionally, the IMA provides the Secretary of State with powers to even remove unaccompanied children in prescribed circumstances. And this is all set out on the slides. I'm very conscious of time, so I'm going to skip this part of the presentation. You can see them there. Just one comment to make, that again, the Act allows the Secretary of State a wide discretion to include further categories in which the Secretary of State has a power to remove unaccompanied children. And I think it is worrying that the Secretary of State has such a broad discretion to include further circumstances in which it might do so. Now, the second exception, where the duty to remove is suspended, is for certain types, but very narrow, certain types of victims of trafficking. So generally, the headline point is the removal duty does apply to victims of trafficking. Yeah, where a person with a reasonable grounds decision is cooperating with law enforcement agencies in the connection with the investigation or prosecution of an offence relating to their trafficking history, in these very narrow circumstances, the duty to remove is again suspended. Then coming on to the third exception, and it's again an interesting one, and shows that really the Illegal Migration Act was in response to the Rwanda litigation, very much so, because this is where the European Court of Human Rights has issued an interim measure preventing removal. Importantly, and the reason why I say it was in response to Rwanda, because of course there were interim relief proceedings going on back in June 2022, and there we, at the very 11th hour, as we can testify because we were in the Court of Appeal at around 9:30 in the evening, removals to Rwanda only didn't take place back in June 2022 because one of the claimants had received a Rule 39 indication, so an interim measure from the Strasbourg court. And on that basis, we were then able to go to the Court of Appeal and again apply for interim relief from our domestic courts. As a result of that, and up to that point, the Secretary of State tried to oppose interim relief. And because of this instance, perhaps, they now put the exception to the duty to remove into the IMA, because the important thing, and David's going to talk about it in more detail, it's not enough to only have an interim measure in place for the particular person. But in addition to that, for the duty to remove to be disapplied, a Minister of the Crown has to personally determine that the removal duty does not apply. So in essence, it's a Minister of the Crown that determines whether someone with an interim measure is actually not to be removed from the United Kingdom. Okay, now very briefly, because I'm very conscious of time, I'm going to talk about challenging removal to a safe third country if the removal duty applies. Now, Section 5, the relevance of this actually Section 5 of the IMA rather than Section 2, but where the duty to remove applies, the Secretary of State has to declare inadmissible any asylum claim and any human rights claim that concerns the person's country of citizenship or origin. Yeah, this is really another crazy provision of the Act, because the effect of that is that there's no substantive consideration of protection claims in the UK at all, really, and there's no right of appeal to the immigration tribunals in these circumstances. Yeah, and given what I said before, that the duty to remove applies to the vast majority of asylum seekers in the UK, this really is what the UNHCR also pointed out, a ban on claiming asylum in the UK for most people. Now, people can still claim that removal to a proposed third country would breach their human rights, but the remedy against refusal of such a claim would not be a right of appeal, but instead would be judicial review. And importantly, that judicial review challenge would be non-suspensive. And that is where suspensive claims come into play. But because Alex is going to talk about this in his section, without further ado, I'm going to hand over to
Okay, great. Thanks very much. Alex Grigg is going to appear remotely, another colleague who acted in the Rwanda litigation in the early interim stages.
Yes, hello, good evening. I'm Alex Grigg, and I'm the odd one out here, not just because I'm appearing remotely, but I was part of one of the other teams instructed by Duncan Lewis for various individual clients, most of whom were removed from the scheme pre-litigation. But then in the courts, HTN Vietnam and the generic AAA and others claim, and was involved in the High Court and Court of Appeal interim relief hearings, which are going to be focusing on also the application to Strasbourg, which David will be talking about in more detail, and then in the High Court JR and drafting grounds to the Court of Appeal. I'm going to start by talking about interim relief in the domestic court and what we've learnt from the Rwanda experience. And then, of course, what we need to be ready to deal with under the 2023 Act. And David will then pick up in more detail on Strasbourg. As we're all aware, there was nothing normal about the Rwanda experience. As Eva has touched on, the afternoon of the first proposed removal flight, 14th of June last year, Mr. Justice Swift had refused applications several of us here had made in court that morning. Some of us waited in chambers to hear which out of hours Court of Appeal judge we might need to address over the telephone that evening. And while busily drafting grounds of appeal as the plane warmed up on the tarmac, and at about 8 p.m., about 30 minutes notice, and a slightly comic sprint down the road to the RCJ, we were summoned before 3 Court of Appeal judges, including Master of the Rolls in person. And thanks to Strasbourg's intervention, now entirely vindicated by the unanimous Supreme Court in finding risk of harm in Rwanda, that court, on the evening of the flight, granted us interim relief, and never has there been greater relief. If the High Court had followed earlier that day, and the questions it had asked itself had felt heavily weighed upon by executive pressure, Supreme Court's unanimous verdict has now highlighted how very wrong it was, and what a huge miscarriage of justice would have occurred without the interim relief aided by Strasbourg intervention. The importance of effective domestic interim relief to allow cases to be heard fairly and to avoid irreparable harm has never been more clear. The Rwanda experience shines new light on the unique importance of making early and effective relief applications in public law cases, and allows all of us gathered together here to help to develop a fair and, above all, a safer regime for the future. So in June last year, Mr. Justice Swift, asked to decide whether to grant interim relief against the Rwanda removals, had to ask himself 2 principal questions. Firstly, was there a prima facie case for judicial review of the removal and inadmissibility decisions? And secondly, did the balance of convenience favour granting or refusing relief? The second of those questions that will normally be decisive, and was decisive for Mr. Justice Swift. But the phrase balance of convenience originates in ordinary civil law. Its application in the public law context is, of course, highly sensitive. In these removal cases, what is at stake is not for example, whether a boundary wall can be moved, but at least potentially, as the Supreme Court accepted, matters of life and death. That's not to denigrate the important issues which can arise in ordinary civil litigation, but we might hope the court wouldn't permit the executive to place lives at risk simply because doing so is convenient for the government of the day. It's perhaps more apt to describe the real issue in the way that it was put by Lord Bridge back in 1990. In the public law context, as part of the factor table, Lord Bridge saying, the court shall choose the course which in all the circumstances appears to offer the best prospect that eventual injustice will be avoided or minimum. In 1991, with that test in mind, Lord Donaldson, as Master of the Rolls, held in Muboyayi, that the court should not permit a would-be immigrant to be compulsorily removed from its jurisdiction if he has sought the protection and assistance of the court. And the result would be to render any subsequent order quashing a decision to refuse leave to enter less effective. We and other counsel representing claimants in the Rwanda cohort made what I think can fairly be called robust submission to the High Court, adopting these principles and explaining why much the greater risk of injustice and harm arose if the removals were allowed to go ahead. What was at stake for the Secretary of State was the risk of the implementation of her policy being delayed in a context where there were complex factual issues that simply couldn't have been properly assessed by the Home Office in the time available. Conversely, what was at stake for our clients was the prospect of refoulement from or persecution in Rwanda. So in such circumstances, a much higher level of caution than was exercised by the High Court was plainly required. As Isaac has touched on, often key to success in interim relief as well was where those general submissions were supplemented, where possible, by evidence of particular vulnerability in individual cases. The timetable within which the lawyers involved, both solicitors and counsel, had needed to prepare those applications, the point to which I'll come back, meant this wasn't, of course, always possible. Always, of course, fair to say that those submissions, strong as they were, didn't find favour in the High Court at the initial interim relief stage, nor were the appellate courts, at first, minded to intervene. It seems very likely that if Strasbourg hadn't made its ruling, the interim relief appeals in which the present counsel were involved might have met the same fate as those the earlier applications dismissed by the Supreme Court. Despite much political invective, Strasbourg's intervention has been fully vindicated by the success of the claim in both the Court of Appeal and the Supreme Court. It's therefore worth pausing to ask the following two questions. Firstly, what lessons we as lawyers representing claimants can learn from the experience seeking relief domestically last summer? Secondly, what lessons the judiciary might be now taking home from the same? Lessons from the Rwanda experience. First, it was necessary to prepare the applications for interim relief at substantial pace. This may seem an obvious point, but it's one worth stressing. It was an inevitable consequence of the government's timetable, which left very little time between initial notification of intent, the inadmissibility and removal decisions, and then the proposed date of removal. And the government may think that that approach was vindicated by the rejection of the claimant's fairness challenge in both the High Court and the Court of Appeal. It seems likely, therefore, that the government will adopt similar approaches in future, leaving individuals little time to prepare a case resisting removal. Whether the government would be justified in doing so is, of course, a different question. Consideration of the fairness issue in the High Court and Court of Appeal was coloured by the fact that by the time the case had reached that stage, all claimants had had the opportunity to acquire further evidence and make further representations. That, I would say, is far from justifying the initial rush to get on with removals, even before claimants had had that opportunity. And this was in spite of the words of Lord Justice Sedley being brought to the interim relief court, and Sedley echoing Bingham in Lord Bingham in Sir Kumar and Lord Wolfe in Fayed, Sedley in the RLC case, emphasising that the executive is not entitled to sacrifice fairness on the altar of speed and convenience, much less of expediency. One can only hope that those words will resonate more strongly in light of the Supreme Court's findings, if we have to go through a similar process again. It is likely, assuming that similar removal timetables are adopted by a government in future, that such fairness argument would have a very significant role to play, at very least at the interim relief stage. So, secondly, Duncan Lewis and all the other lawyers involved, of course, did an excellent job preparing the human rights claims and interim relief applications, notwithstanding these almost unprecedented time constraints. But it's worth stressing that the earlier counsel can be involved, the better. In particular, any need to instruct experts to provide reports, for example, expert medical or psychiatric assessment, needs to be identified at as early a stage as possible. It will then be possible to have a report, even in interim form, before the court considering interim relief. And if that's not possible, that may itself, of course, support the case for interim relief, if the court can see that every sensible step has been taken. Thirdly, and relatedly, while in a case like this, the generic or systemic points may seem to take on primary importance, they should be supported so far as possible by case-specific considerations, mental health or other vulnerability, evidence of family ties, etc. So much of the success in the Home Office to concede individual cases and take people off the flight without needing the court's intervention was the result of diligently presented individual evidence. Fourth, the significant skepticism which the claimants were treated contrasts with the court's willingness to accept at face value the evidence of and assurances given by the Secretary of State. In one case in which I was involved, there was a dispute about what was said at the initial screening interview, and regardless of what was said and how much had in fact been understood by the claimant, despite some criticism of the Secretary of State's witness evidence, and a surprising and unusual move at 11:03 p.m. the night before the planned flight, when the clerk to Mr. Justice Swift requested of GLD that witness statements be provided, confirming the Home Office position. The court, in those unusual circumstances, ultimately accepted Home Office evidence in full. More broadly, the court at the interim relief stage, and indeed in the substantive JAR at the High Court stage, was willing to place substantial weight on the Secretary of State's assessment that Rwanda was safe, and placed significant reliance on assurances that best endeavours would be exercised to bring back anyone who was removed to Rwanda if the JRs ultimately succeeded. Have a new slide, please. Thank you. So far as the first point, Secretary of State's assessment of Rwanda's safety has since been thoroughly undermined. It's worth reading closely the damning comments made by the Supreme Court in this respect. The court recognised that while officials have substantial expertise, and words of the court here, ministers do not, however, necessarily act on the advice of their officials. So through no fault of the civil servants involved, The pressures placed on the civil service by the Secretary of State resulted in the mistaken acceptance of assurances without close examination of supporting evidence. The judiciary, in particular the Supreme Court, has almost always been guarded with their criticism of ministers. That Lords Reid and Lloyd-Jones went so far in the Rwanda judgment is a promising indication that courts at all levels will not in future be so ready to assume that the government's assessment of safety is properly and fully considered. In particular, if the government is seeking to act with the same sort of pace as it did in the Rwanda case. While overt criticism of ministers outside of strictly legal grounds should be avoided, and judges just don't like it, should this government or the next pursue any equivalent or similar policy, it should be possible to make this point sensible. It would have particular force at the interim relief stage, where both claimants and the court are necessarily acting with limited information. So it's to be hoped that the courts will have noted that the confidence they initially placed in the government's assessment proved ultimately not to be justified. The government in future may need to do more at the interim relief stage than simply assert that its position is considered and justified. And claimants should seek to encourage the courts to guard their own jurisdiction more jealously. And as was uncontroversial when Lord Donaldson spoke in 1991, be more reluctant to permit the Secretary of State to remove claimants from the court's jurisdiction. Everything I've spoken about so far concerns the ordinary interim relief regime as it was applied during the Rwanda litigation and as it might be applied in future. The Illegal Migration Act 2023, if it is maintained, will, however, mark a substantial departure from that ordinary regime. For the moment, in the aftermath of the Supreme Court's judgment on the Rwanda scheme, none of us know whether, and if so, to what extent, the scheme of the 2023 Act will be maintained. That scheme is, after all, premised on the government being able to remove large numbers of foreign nationals to friendly third countries, something which, for the moment, the government is simply not in a position to do. But perhaps the government will try to renew the Rwanda scheme or create a similar scheme with another, purportedly safer, third state. If nothing else, the 2023 Act indicates the extent to which this government at least will go to limit judicial scrutiny of removals. So it's well worth considering the detail of the Act very carefully. So far as interim relief is concerned, the headline provision is Section 54. That has not yet been brought into force. It provides that no court may grant an interim remedy that prevents or delays a removal pursuant to a decision made under the Act. New slide, please. So that is, in effect, an ouster provision, i.e. a provision that ousts what would otherwise be the jurisdiction of the courts. The conventional approach to such provisions has been to read them down by treating decision as only meaning lawful decision. A legally flawed decision is only a purported decision, not protected by the ouster. That approach was reinforced by the Supreme Court in Privacy International. Though it's worth noting that there was a significant minority, which included Lord Reid, preferring to give effect to a clearly expressed ouster. The IMA 2023 attempts to get round this sort of reasoning by defining decision as including any purported decision. And similar language has been accepted by the High Court in the Oceana case, and very recently by the Court of Appeal in LA, Albania, as effectively ousting the former CART judicial review jurisdiction. That doesn't mean that the same decision would be reached in relation to the 2023 Act. It's not a straightforward question of linguistic interpretation. The real issue lies in two competing facets of the rule of law. On the one hand, the rule of law, of course, requires that the courts obey the instructions given to it by Parliament. But on the other, the rule of law requires that the executive likewise act within the constraints of law, which very often requires the oversight of the court through effective judicial review. The context of Oceana and LA, Albania, judicial review of the upper tribunal, following a refusal of permission to appeal by both the first-tier tribunal and the upper tribunal, is very different to the ouster of interim relief proposed by the IMA 2023. And the ouster of CART ARs is only partial. Judicial review for bad faith and serious procedural defect remains available. The ouster of interim relief in the IMA 2023 is, by contrast, complete. It is, however, coupled with the introduction of suspensive claims, and these are set out at sections 42 to 53. These are clearly designed to set off judicial concern that legal scrutiny is being avoided entirely. There's not time today to discuss the detail of these provisions, which are complex, but they allow a person faced with removal under the Act to claim that either, first, removal would cause serious harm, or second, the conditions for removal are not in fact met. The Secretary of State might grant or refuse that claim or certify it as clearly unfounded. There's a right to appeal on an accelerated time frame to the upper tribunal if a suspensive claim is refused, and if the claim is certified, an appeal can be brought only with the tribunal's permission. A refusal of permission can only be challenged on very limited grounds. The timetables for bringing and preparing this challenge are very tight. It's therefore not difficult to envisage circumstances in which there would be good grounds to challenge an upper tribunal decision under the Act, allowing removal to go ahead. Very often, the Act will either forbid that challenge entirely or bar the claimant for obtaining any interim relief while it is considered. The only remedy would be to argue that the various ousters are not effective. One might argue that their effect is narrower than it seems, or that they represent an affront to the rule of law, which the courts simply should not tolerate. That's the sort of showdown for which the present Supreme Court has expressed very little appetite. But as the Rwanda judgment itself shows, this is not a solely pro-executive court. There are ways of reasoning, even in these difficult constitutional issues, which it will find more attractive than others. And it was Lord Reid, after all, who gave the landmark decision in unison, championing the rule of law and the importance of access to the courts. We might hope that these issues never have to be tested. There may, after all, be an election in the distant future. And who knows what approach a different government will take. We don't, for the moment, have to accept that the government has successfully, by the IMA 2023, demolish the domestic interim relief jurisdiction in immigration cases. Never has its importance been more evident. By continuing to fight these cases, we can save individuals from harm, and we can help remind our courts of their vital independent role in doing so. Everyone here has a vital role in helping the living instrument of our legal system to continue saving lives. Thank you very much.
Thank you very much, Alex. Sorry that we've slightly run over time there, but I'm not going to take any time away from the next speaker, David Sellwood, who was also a part of it throughout, acted in one of the Rwanda cases, the case of RM, including the Supreme Court. And David's going to talk about the Strasbourg interim measures going forward. So thank you very much.
Thank you very much. I'm going to briefly speak about 3 discrete points. First, Strasbourg's interim measures procedure and its application to date. Second, proposed reforms to that procedure. And third, how it all fits with the Illegal Migration Act. Interim measures in Strasbourg are governed by Rule 39 of the Court's rules. You'll see from the slides that I think will be handed out after the seminar that the wording of the rule is very broad and very wide. Essentially, the Court can indicate to the parties any interim measures that should be adopted in the interests of those parties or for the proper conduct of proceedings. Where appropriate, whoever is deciding whether to issue interim measures may request information from the parties in order to determine the issue. And that's it. That rule, very broad as it is, has a very specific application in practice. And I've highlighted 7 principles that you'll see throughout the jurisprudence on point. First, interim measures are urgent measures, which according to the Court's well-established practice, apply only where there is an imminent risk of irreparable harm. Second, they're only granted on an exceptional basis. Third, in a majority of cases, interim measures are made to suspend the expulsion of an individual, whether that be as a result of extradition or exclusion. Fourth, when such measures are made, they're indicated to the respondent state, but the Court can also indicate the measures to applicants. For example, as we've seen in the case of Iliescu and others against Moldova and Russia from 2004, the Court asked one of the applicants to stop a hunger strike he was pursuing by way of an interim measure. Fifth, the Court considers that such applications on an individual basis, on the papers. There's no oral hearing and there's no right of an appeal against a subsequent decision. Sixth, the length of the measure generally covers the whole duration of proceedings before the Court, but can last for shorter periods. And seventh, interim measures may be lifted at any time, particularly where proceedings before the Court are not maintained. Now, those principles are important for the purposes of what I'm going to go on to say in relation to the proposed changes to the rule and to the Illegal Migration Act. Interim measures are granted in a range of cases. They include cases where there is a risk of torture, inhuman or degrading punishment or treatment, such as asylum seekers fearing persecution, in expulsion cases, raising issues relating to ill health, and have been granted in cases I'm sure many of you are familiar with, such as D in the UK, N in the UK, Papashvili in Belgium, and others. Cases relating to the potential sentence of death or life imprisonment if an applicant is extradited also attract special interim measures. They include, again, cases you would all be familiar with, the case of Öcalan and Turkey, and the case of Baba Ahmed and others against the UK, 2 such cases. Also cases where there's a real risk of a flagrant denial of justice. Again, cases you'll be familiar with. Case of Sering in the UK and Othman and Qatar in the UK as well. Exceptionally, in cases that concern the right to private and family life, they may also be granted, where there is potential irreparable risk of harm in relation to the right to private and family life. And we see that in the case of Amaroli in Denmark, where deportation to Iran would have severed an applicant's family relationship with a Danish wife and 2 children and a daughter-in-law. In that case, interim measures were granted. Are interim measures legally binding? Well, as already mentioned, they arise from the rules of the court, not directly from the convention itself. The court's position, the Strasbourg court's position, however, is that member states are under an obligation to comply with interim measures. And this stems from a case, a Grand Chamber case from 2005, Mehmet Kolov and Ashkarov against Turkey. And in that case, the applicants were Uzbek nationals. They'd been arrested in Turkey on suspicion of murder, and they'd been extradited to Uzbekistan despite interim measures prohibiting their removal. The Grand Chamber was crystal clear in what should arise as a result. It concluded the failure to comply with interim measures amounted to a failure to comply with Article 34 of the Convention, which requires member states to refrain from hindering in any way the effective exercise of an applicant's right to make an application to the court where they claim to be a victim of a violation. So, non-compliance with interim measures can, according to the court, prevent it from effectively examining a complaint and hinders the effective exercise of an applicant's rights therein. The Grand Chamber also concluded that non-compliance with interim measures undermines Article 1 of the Convention, a member state's undertaking to protect the rights and freedoms therein. The court has followed these principles in subsequent cases, including the case of Vladi in Moldova and Kudrolin and Russia, and many, many other cases. The court has proposed a number of amendments to the way in which it deals with interim measures. They arise in the context of wider reform of the court. They may also be explained to some extent by the exponential rise in the number of interim measures that have been sought and granted. For example, in 2021, the court made 1,925 decisions on interim measures, of which only 232 were granted. In contrast, in 2022, there were 3,106 decisions, of which 1,094 applications were granted. The proposed amendments were outlined in a press release from the Registrar of the Court on the 13th of November 2023, 2 days before the Supreme Court handed down judgment in the Rwanda case. The press release begins by underlining the importance of interim measures. It notes measures can be imposed until further notice or for a limited period of time, depending on the circumstances, and that parties may request the court to reconsider its decision. And as to the proposed amendments, which have been submitted to member states for comment, if accepted, they will form the basis of an updated practice direction and include disclosure of the identity of the judge who determines the interim measures request, maintaining the practice of providing reasons for such measures on an ad hoc basis and issuing press statements where required, issuing formal judicial decisions to be sent to the parties, and maintaining the established practice of adjourning the examination of requests for interim measures and requesting state parties submit information in those circumstances where the situation is not considered extremely urgent, where the information that the applicant has submitted to the court was not sufficient to enable it to examine the request. Elsewhere, it's been reported that the court also proposes to change the actual wording of Rule 39 to include the fact that such measures are only granted in exceptional circumstances where an imminent risk if irreparable harm arises, which could not be susceptible to reparation, restoration, or adequate compensation. Does all of that sound familiar? Well, arguably, the proposed amendments and the new practice direction are not actually radically different from the current practice. They perhaps provide a more rigorous, transparent, and flexible procedure, making it easier for opposing parties to object to a request or a grant of interim relief in a given case. But the substance, in my opinion, of the applicable tests appear largely to be unchanged. So where does all of this fit in with the Illegal Migration Act? Again, overall, the context is important, which is the UK government and perhaps other member states' frustration with what it sees as a lack of transparency and rigour in the interim measures process. And we see that from Lord Bellamy's speech in the House of Lords in June of this year, which I've outlined on the slides that you will get after the presentation. The response to those concerns are crystallised in section 55 of the Act, which is not yet in force. Essentially, section 55(2) allows a minister to exercise discretion and override the duty under section 2(1) of the Act to make arrangements for an individual's removal from the UK, where interim measures have been ordered by way of Rule 39. Section 55(5) sets out a number of non-exhaustive considerations the minister can have regard to when considering whether or not to exercise that discretion. Specifically, A, whether the government was given an opportunity to present observations and information before the interim measure was granted. B, the form of the decision indicating interim measures. C, whether the Strasbourg court will take into account any representations made by the government seeking reconsideration without undue delay of the decision to indicate interim measures. And D, the likely duration of the interim measure and the timing of any substantive determination by the Strasbourg court. If the minister doesn't make a decision under section 55(2), then courts and tribunals, the Secretary of State and immigration officers cannot have regard to an interim measure. And we see that in sections 55(6) and 55(7). But crucially, under section 55(9), nothing in the Act requires the Secretary of State or an immigration officer to effect removal of a person pending a decision from the minister as to whether or not to exercise their discretion under section 55(2). So, in essence, interim measures can be ignored to effect removal under section 55 if the minister decides to do so. And if so, courts and tribunals, on the face of it, cannot prevent that from happening. It's worth noting in passing that the UK now appears to be the only country in Europe where government ministers have a specific power enshrined in domestic law to ignore interim measures. Although bear in mind that other countries have, in practice, ignored interim measures on a number of occasions. So, to briefly conclude with 3 points. First, three questions. Will section 55 of the 2023 Act ever come into force? Well, that depends on what happens next in the next 12 months and whether or not we have a change in government. Second, if it does come into force, will it ever be used to override interim measures? Well, again, that also depends on what happens in the next 12 months and beyond. But bear in mind the proposed changes to Rule 39 from the Strasbourg court raise a number of questions as to whether section 55(5) may be answered in a way in the future. The questions therein may be answered in a way that is beneficial to the government and therefore avoid a showdown between the Strasbourg court and the government anyway. And third, does section 55 comply with the ECHR? Well, it can if it's used to override the duty to remove under section 2, but equally it can come into direct conflict with the ECHR via articles 34 and 1 if it overrides interim measures. Thank you very much.
I think that's really important for us going forwards. And then I'd like to ask finally, Adrian Berry can talk about non-reformal and UK third country removal. Again, Adrian Berry, part of the Rwanda team, my team, it's up to including the Supreme Court and leading senior junior. Thank you.
Thank you. I won't detain us from the drink for too long. Hopefully we have one or two slides flashing in front of you, not so fast as to induce fit. Although I almost had one myself when we win the judgment in the Supreme Court. And what do? They decide, oh, let's have a treaty and a new Act of Parliament. That'll show them. You know, they come along with their funny human rights attitudes and their Article 3 and their prohibition on torture and inhuman and degrading treatment. And then, well, we've got this other thing. Well, we have to think ourselves, what are we going to do about that? Because there are things that we have to think about. It won't be enough to do it all over again and to repeat the idea that, well, it's very risky to go through Rwanda. There's a risk of onward reform law. The procedures they're not great, as Lord Reid set out in his judgment. How are we going to deal with that? But there are things which we can take from what we've got and fashion a response, both in terms of our litigation and also in terms of the broader policy work that we do. So if we look at the idea that there are going to be two things, a treaty potentially and also a new Act of Parliament, what sort of things do we have in our toolbox? Well, we have what will be left of human rights if an Act of Parliament contains a purposive clause saying that either the Section 6 of the Human Rights Act is limited in some way, so or that there's a special purposive clause of the sort that we find in Section 1 of the Illegal Migration Act, which looks at taking away the interpretive provisions of the Human Rights Act and replacing and creating a self-contained code within the Illegal Migration Act of how to construe and interpret the provisions of that specific act according to its objects. So we might have some human rights tools. It depends on who's occupying the Home Office on any given day, who's been appointed to be Foreign Secretary, who has to deal with the fallout for the Good Friday Agreement and with relations with the EU, because of course human rights provisions are baked into the Trade and Cooperation Agreement with the EU, with the Withdrawal Agreement, and not just the Good Friday Agreement or the devolution settlements. So we've got that. But the other thing which we have is, of course, the principle of non-refoulement, and the idea that you can't have onward refoulement. And the question for us, alongside human rights, is how do we get around the idea that there might be a piece of primary legislation which is causing us difficulty? If that piece of primary legislation, a new act, deems Rwanda to be safe, what are we going to do? And at the moment, we've had the principle of non-refoulement, the idea that onward refoulement, there's a risk of that being the main reason that the principal way in which these cases succeeded in the Supreme Court. We've had that articulated through the immigration rules, through paragraph 345B of the immigration rules, when looking at the question of whether a person could be removed to a safe third country, to Rwanda. And we've also had it baked into various pieces of legislation, into Schedule 3 of the 2004 Asylum and Treatment of Claimants Act, into the provisions of the Nationality, Immigration and Asylum Act 2002 regarding appeals, and into the Asylum and Immigration Appeals Act of 1993, which lays down a rule that nothing in the immigration rules can be contrary to the Refugee Convention. So we've had these sorts of things in our domestic law, and that's been backed up by international treaty law. I would say we find that the principle of non-refoulement, albeit that there is a limitation clause, is of course found in Article 33 of the Refugee Convention, and obviously that has been reflected in the architecture of the 2004 Asylum and Immigration Act, and also via Article 3 of the European Convention on Human Rights, as we've seen in the cases of Söring and MSS against Greece and Belgium. And we know from other cases, the case of Bugdike, which I always mispronounce, that can include onward refoulement to a third country, if you're removed to one country, but you're at risk of onward refoulement to yet another country. So we have it in our domestic legislation at the moment, and then we also have it backed up in international treaties which have been given effect in domestic law, the Refugee Convention via the immigration rules, and the Convention on Human Rights via the Human Rights Act. But what if the new Act, by the doctrine of implied repeal or expressly, limits our ability to rely on those provisions? Can we look at customary international law to come to the rescue? And if we had the slides, which obviously, which I know you're all imagining right now, you would see that there are some dicta from judgments of the Inter-American Court on Human Rights, declarations from the UN General Assembly, and statements of state practice that state parties who are parties to the Refugee Convention have agreed to, which establish that this principle of non-refoulement, that you can't be returned to a place where you're at risk of torture or inhuman or degrading treatment, is baked into customary international law. Now, we have, obviously, in the UK, a dualist system of law. We have a question where treaties have to be transposed, but customary international law, absent any rule in domestic practice to the contrary, may also form part of UK law in a certain sort of way. Now, that doesn't mean it can't be displaced by a statute at one level, but it can take its place. And so one issue for us to consider as we look at a rejigged constitutional architecture whereby the Rwanda scheme could be revived if there's an act of parliament, is to wonder to ourselves, well, is it enough that we might be able to receive the principle of non-refoulement via customary international law into the domestic legal order? If we can, and there's a method of transposition that the courts are willing to recognise, can we then thereafter use it against the acts of parliament? Well, that would be a tall order, because ordinarily an act of parliament in a sort of hierarchy of things in our domestic legal order may trump anything such as customary international law or a piece of common law. But what if it was a peremptory norm? What if it was jus cogens or jus cogens in the idea that it's of such importance, this rule of customary international law, that it takes a higher order in international law, and that feeds into how it's to be approached in domestic law. Although there are lots of international treaties which are considered by UK courts, often of a commercial character rather than of a human rights character, there are very few which obviously breach peremptory norms of international law, which arise out of customary international law. Yet the prohibition on torture or being removed to a place where you're at risk of torture or inhuman or degrading treatment may have that quality. And if it does, what would that do to a treaty? Because I'm sure you will have in mind the Vienna Convention on the Law of Treaties, which says that a treaty which is contrary to a peremptory norm of international law can be void. And so there are questions for us to consider about how we look at that. Now, we don't have the detail of any act of parliament, if they get any bill. There's a real doubt as to whether or not they can get it through the House of Lords. It wasn't in the Conservative Party manifesto, so the Salisbury Convention, that the Law of Lords gives way to government business that's been the subject of the governing party's manifesto at a general election, doesn't apply, and there isn't enough time to use the Parliament Acts to get it through before the next general election. So there are a number of reasons as to why they might not get it. But if they do, the question of how the courts consider a treaty which may be in conflict with a peremptory norm will apply. And then the second consideration that we have to think about in that context is if the Act of Parliament, if it were to reach the statute book, was predicated upon that treaty, and that treaty itself was contrary to a peremptory norm of customary international law, the principle of non-refoulement, how would that play out in the domestic courts? So we're not out of road simply because they consider an act of parliament if it goes into the statute book. These are difficult questions. They're not easy questions to answer. And I'm not saying we have a ready answer to them. But I am saying that if the government's going to change the constitutional structure in order to get around a judicial holding that there is a risk of onward refoulement, then we have to think creatively about how we respond to that using the tools at our disposal. We may have the remnants of the Human Rights Act, we may have bits of jurisdiction to go to Strasbourg. We may also still be able to rely via these instruments on using the principle of non-refoulement as well, because we know that there is risk, because the Supreme Court has told us that there is risk, as had the Court of Appeal before it. I'm going to stop there. Hopefully you'll get the slides. It should make more sense when you can see them. But thank you very much for your time. Thank you.
Thank you very much, Adrian. In fact, it made perfect sense to me, and it was really, really good to end on that positive note, because we know there's quite a lot of legal developments to come, and in the context of what the Parliament might be presented with in the next 12 months. I'm conscious of time. There is a question online. I'm just going to take that question first because I've been looking at it since 6:40, and, which is, this is from Dinesh. What are the long-term effects of the newly introduced Section 8AA, 1 and 2 of the 71 Act for Channel migrants? And just to remind you, 8AA is persons who are ineligible for leave to enter or remain or entry clearance. That is, the section applies to any person who's ever met the 4 conditions in Section 2, which you heard from Eva. And the short answer, just because leave must not be given to those persons unless they are limited persons and victims of slavery or unaccompanied children. But then there is a get out clause there. The Secretary of State may give the person limited leave to enter if the person has left or been removed from the UK after they've become a person within subsection 1, which is the person's meeting those conditions. And if the Secretary of State considers that failure to give leave or grant entry clearance or would contravene, or ETA would contravene the UK's obligations under UTHR, or there are other exceptional circumstances which apply. So the peculiarity of this section that the Secretary of State can give leave to these persons while still being under a continuing duty to remove them under Section 2. So I think that will obviously end up, if those relevant provisions are commenced under Section 2, there will have to be litigation for persons who are ultimately granted status under on that limited basis, or even persons who refuse, because there is obviously a discretion there. But I think it's an interesting question, and of course one that we will be looking at again in the future, I think. So I think I will leave that question there. I don't know if anyone else has got any other questions here. But I just wanted to oh, sorry, question here, yes.
It's not actually a question, it's just clarification. I think it was the conditions when you can apply the criminal duty. You mentioned something about someone not coming directly from the place to fear prosecution. I just didn't get that point. I just want clarification.
So this is the third condition,
Yeah.
and the third condition is about essentially person who've travelled through a safe third country as part of their journey to the UK.
And that safe country is decided by migration.
No, what the IMA does is to really narrow the meaning of what coming directly to the UK actually means. So even where a person has only passed through another country or stopped in another country, then that will be sufficient for them to be called by condition 3 and to fall within condition 3. So essentially you can't argue things like I was under the control of an agent, therefore I had no means of, for example, claiming asylum elsewhere. You know, it's the mere passing through another country that is sufficient for a person to be called by the duty.
Thank you.
Okay, question there, yes, thank you.
2 questions. So, first one, the panel, do you believe that the government believes that if this emergency legislation is passed that renders Rwanda a safe country, that would allow it to bypass the recent Rwanda ruling? Is that what they believe? And the second one is to Adrian. Is your point that customary international law relating to like Liv Kogan's norms might be automatically kind of inside English martial law without the need for domestic provisions to be included, such that even if that emergency legislation came in, it might still go against that norm.
Anyone else want to answer these?
Who knows?
Yes.
I think probably it's literally impossible to say, isn't it? It could all just be political theatre, or they could believe it. There was a picture of James Eady and David Panic walking out of a meeting, and they had a big, thick document which had its name on it. So presumably they've been advising them on whether it would work, but what they're advised. Yeah, I mean, my answer would be who knows. Somebody might have a better answer than that.
I mean, my suggestion, one suggestion would be that then be whilst we have the Human Rights Act, we would use it, and it would be in conflict with the Human Rights Act. So we'd have another setup there for Strasbourg potentially, if not domestic.
My guess is they don't actually really care whether it works or not, as long as they have something to argue about.
I'm not saying a peremptory norm that's recognised as operating within domestic legal order trumps an act of parliament. I'm not saying that. I'm saying that the question of how you get the principle of non-refoulement to be considered in the context where the doctrine of implied repeal might apply if an act replaces it, declares Rwanda to be safe, which obviously we know is a legal fiction, then at the very least all of the non-refoulement provisions in previous legislation might be displaced by the new act on traditional principles. If that new act contains or is predicated upon a treaty which is itself invalid because if that question can be considered by an English court on the basis that it conflicts with a peremptory law, what does the court do with the remaining legislation? How is it going to approach it? If the court needs some help with a declaratory act which says that Rwanda is safe, it needs every millimetre of assistance it can get from not simply saying we're not going to recognise the validity of an act of parliament. It needs to be able to contextualise it in some fashion. So if we can bring the principle of non-refoulement back into play in the domestic legal order in some fashion, because it's a peremptory law, that may assist, depending on the particularity of the act in question and the way in which it's related to any treaty, to give the court something to bite on in making this in its consideration of any new provision. So obviously we don't know the detail of what the government are proposing yet, either in the treaty or in the act, but we're looking for, if you like, a back door for the principle of non-refoulement. We may have one, and we just have to explore how it will be recognised in the domestic legal order.
Remember, it was the Supreme Court that put on the table from international law point of its own volition.
So Reid mentions
it. So, and there wasn't any submissions on that point because it wasn't a matter in issue. So obviously other people have been thinking about it already.
Yeah, I think that's a really important point. That's the point that Lord Reid led with when he gave the summary of the judgment. He emphasised how that it was other international treaties that were binding on the UK. In terms of international law, not just the HRA, not just the ECHR. And he started out with non-refoulement as a core principle of international law. And so that gives us hope for where we think that argument is going. I recognise what you say about Lord Reid's, I think it was Alex, about Lord Reid's dissent in the, I think the privacy case. He likes black letter law, of course, but so far as this case was concerned, it's important that we didn't really go to very many authorities in the Supreme Court, Hoffman, Development, Ilias, one or two others. But I know for the Supreme Court, for a Supreme Court case, it's really unheard of to have a small bundle of authorities of which you only looked at half a dozen. And so this case was about the facts applying those principles that we know under the HRA to the factual analysis and context that we had. Really, really striking judgment in that respect. Just because we've run over time, and also because it's a cold Wednesday evening, I'm going to draw this to a close, but say thank you very much indeed for coming. Just to recognise this is the third of our series. The other presentations that we've done on the Illegal Migration Act are on YouTube, that's right. And we have also, so parts 1 and 2 on YouTube. And we have an upcoming event, which is on the 6th of December, not to do with the Illegal Migration Act, but on the Brick House inquiry, what lessons have been learned, and that is a free conference on the afternoon of that. So if you'd like to come hybrid or in person, certainly hybrid tickets are available if in person. Anyway, thank you very much indeed. Thank you.